Sean Claggett. I'm a trial lawyer at Claggett & Sykes Law Firm. I tell people this, it's like doing a trial and the excitement of preparing, but knowing that you're preparing better than everybody else, knowing that you're ready better than everybody else, and then executing it at trial. When it comes to voir dire, the first goal is to create a community where people want to be around each other and they like each other, because that's going to create a positive energy. And that happens because you're a good listener as the attorney when you're asking questions. The other thing is, yeah, you got to get rid of the bad jurors. There's some jurors out there that just doesn't matter. They're never going to find fault for what the defendant did. They hate your client and they've got real bias. A big part of jury selection is getting rid of those jurors for cause, so you don't have to waste a peremptory challenge on them. Your peremptory challenges are gold. And depending on your jurisdiction, you only have so many pieces of gold. The biggest mistake with opening statements that I see is they wait way too long to start working on it. They're trying to do their opening statement the day before trial or a week before trial. We have our opening statements done 3-4 weeks before trial, where it's pretty much final form, where we're testing it in front of focus groups to see what worked and what didn't work, so that if there's revisions that need to be made, we can go make them. You need to talk about what happened. You need to talk about the damages, and then you have to undermine the defenses. I've seen attorneys leave stuff out and then the defense brings it up for the first time and I'm like, ooh, that hurt. You completely reduce the impact of a bad fact if you're talking about it first as the plaintiff. By the time they get up and give their opening statement, when they start saying stuff, the jury looks at the defense like, what are you talking about? He already told us. Another thing that's happened in one of our trials is the defense said, we can't even give our opening statement because everything we had just undermined was everything they wanted to say, and we made it look so stupid. And that resulted in a $31 million verdict. When it comes to direct examination in personal injury cases, you're dealing with your clients, the before and after witnesses, the doctors, and a huge mistake is you didn't spend any time with these people beforehand. You cannot explain to a jury the pain and the hurt and the loss if you yourself have not opened yourself up to that family so you can understand what that truly means. The best direct examinations are ones where I don't look at questions. It's all from the heart. Yeah, I know what I'm asking, and it's simple because it's truth. And when you've prepared them right, when they get cross-examined, they just keep going back to their truth. Cross-examination, I am so thankful every time the defense hires an expert, because they give me meat on the bone to go cross and get another person that I know is not being honest. I try to have fun with cross, and I try to be creative, and I really give a lot of thought for each witness and how I'm going to uniquely cross them and expose them to the jury. A point on cross is worth like 3 points on direct. If I'm crushing their witnesses, and I'm proving my case not through my witnesses, through their witnesses. And for me, they're just fun. When it comes to closing arguments, juries want something creative. While transcripts are okay, we learn better from viewing and seeing with our eyes. We're going to be taking the clips or the statements, and we're gathering video clips of all the testimony that we've already been clipping every night, and create some sort of really great interactive close for the jury to just let them remind them of the greatest hits when people were being silly or lying, so that as I'm giving my closing, I'm like, and let's not forget, boom. And you remember this guy? You remember this little doctor, the little guy? Or having a really heartfelt moment, you know, and feeling the pain and bringing that back to them. Failing as a trial lawyer, a plaintiff lawyer, we have other cases. Our clients don't have a second chance. When I finish a trial, I want to be able to look my client in the eye and say, I left it all out there for you. I gave it our very, very best effort. And then you're able to deliver justice. That embrace afterwards, the emotion that's being let out is years and years of anxiety and grief. And it's finally over. To know that you were part of the healing process is pretty powerful. And knowing that you did everything you could and it worked out is and you can feel it. You can just feel the tension letting out of their body, and it's probably the most special hug you're going to get in our industry.